Hello viewers, welcome to Ekam Academy. Today, as part of our daily current affairs discussion, we are going to look into a curious case where a Tamil Nadu minister who was disqualified on the grounds of corruption charges was again asked to be reinstated into the cabinet on the recommendations of the Tamil Nadu cabinet. But what happened? Tamil Nadu governor, he refused to reinstate him into the cabinet. Subsequently, what happened? Tamil Nadu government has approached the Supreme Court saying that governor is not following the aid and advice of the council of ministers. So we look into this particular case, on what grounds a minister can be disqualified, who has the authority with respect to disqualification, and what happened in this particular case, and what are the other Supreme Court judgments in this regard, along with the Representation of People's Act 1951 and its provisions. So without any further delay, let's start the discussion. Here you can see the points of discussion. It is with respect to mainly disqualification of a minister. So first thing we need to know is a minister, it can be at the union level or the state level, he or she can be disqualified on two major grounds. One is under the Representation of People's Act 1951 along with some constitutional provisions. At the same time, on the other side we have is anti-defection. Okay, so these are the two things on which the ministers can be disqualified. Representation of People's Act 1951 and Constitution of India, it has also prescribed some things, and we have defection grounds. So the basic thing we need to know is there are two grounds on which they can be disqualified. So here the who has the authority is different and who has the authority in this regard is different. Okay, so we'll understand in which particular case who have the power to disqualify and all, and what is the background of this case, and what are the articles 102 and 191 and Representation of People's Act. Then we'll understand what are the grounds for disqualification according to the said act, and why did the Tamil Nadu government approach the Supreme Court in this particular case? What actually happened, and is the way forward? If you see in the recent times, we are coming across Tamil Nadu government approaching the Supreme Court very often with respect to the office of governor. So they're very serious on, because they're very unsatisfied with the position of the governor. As the governor, they're raising the reprehensions that governor is not giving assent to the bills and not listening or not adhering to the aid and advice of the Council of Ministers. So in this regard, we'll be looking into what are the constitutional provisions and all. So before that, we need to understand whatever the point of discussion is. There is one minister called Ponmudi. Okay, so he was a cabinet minister in the Tamil Nadu government, and he was disqualified on the grounds of Representation of People's Act 1951 in December 2023 itself. That means almost 2-3 months back, he was disqualified. What are the grounds on which he got disqualified? Means there are allegations that he and his wife, okay, they're having disproportionate assets. Means, normally when they're filing elections and all, they have to give to the Election Commission of India the details of how much assets they have and all. So all those have to be disclosed. But in those assets, they found is what they have given is false information, and they have more than that what they have disclosed. Okay, based on these charges, there were some cases filed in the High Court. In Madras High Court, initially have disqualified him, stating that he has some disproportionate assets and he failed to lodge all those in the Election Commission's details. So then what happened? He was disqualified according to the Madras High Court. Then what happened when he was disqualified under Representation of People's Act? Okay, so then he cannot continue as a minister. No? So then immediately he was removed from the cabinet by the Tamil Nadu governor R.N. Ravi. So then what happened? Then this person, okay, he challenged this decision of Madras High Court, disqualifying him on the grounds of this particular Representation of People's Act, and he went to the Supreme Court of India. So subsequently, recently, 1 week back only, Supreme Court of India have stayed his suspension. Okay, so stayed means suspending his conviction. Okay, so it was suspended. That means temporarily some halt or some pause was given to his disqualification. So on this ground, what happened again? So the Tamil Nadu government is now asking, as his conviction was itself stayed by the Supreme Court of India, then they're asking the Tamil Nadu governor to take back him again into the cabinet. Okay, that was the recommendation forwarded by the State Council of Ministers from Tamil Nadu cabinet to the governor of Telangana. Sorry, Tamil Nadu only. I'm very sorry. So what happened then? So he said, no, I'm not going to reinstate him back into the cabinet. Okay, that is what he have given a suggestion and he has given his word. Then at that time now, Tamil Nadu government has approached the Supreme Court saying that Tamil Nadu governor, he himself is not following the aid and advice of the Council of Ministers, which he has to follow as a constitutional obligation under Article 164 of Indian Constitution. In this regard, we are going to look into these details on what grounds he was disqualified and what are the other grounds on which a person who was elected to the Lok Sabha or the assemblies can be disqualified on the grounds of Representation of People's Act. All these we'll look into this video. Okay, so this forms part of GS paper 2 in Polity and Constitution section, and why it is a news I told you. So Supreme Court has agreed to hear this petition of Tamil Nadu government seeking intervention in reinstating this Ponmudi as a minister. So this is what we have seen. The background, if you see, Madras High Court in 2023 have convicted this person and his wife in disproportionate assets case. Means compared to what he have given the details, more assets were found with him and his wife. Then High Court has convicted a former minister and his wife with almost a 3-year jail term. So under one provision of Representation of People's Act, you can see here, any person, okay, so if any person is convicted of offense of more 2 years or more, if 2 or more years are given as offense punishment, okay, then he cannot contest elections for the next 6 years. Means he will be disqualified to contest elections in the coming 6 years until he gets released. So the same thing, okay, so if you have seen previously, in the same happened in the case of Rahul Gandhi also. So initially when he was convicted for some offense and he was disqualified for more than 2 years imprisonment. Okay, at the time 2 years was given to him also. So he was immediately disqualified, and Lok Sabha secretary has given an order on the same date of issuing of judgment also. That became a controversial thing. Subsequently, Rahul Gandhi approached higher courts, and later in the Supreme Court he got a stay on this order, and again his membership was reinstated in the Lok Sabha. Same case happened here also, but in different cases. Okay, so here what happened, as he was awarded 3-year jail term, that means if 2 years or more means he can be disqualified. No, that is why he was disqualified from the cabinet immediately by the Tamil Nadu governor. So then what happened? He approached the Supreme Court challenging the High Court judgment. So subsequently what happened? So here you need to know what is Article 102 and 191. So Article 102 and 191 deals with the grounds of disqualification. Okay. So 102 is with member of parliament and 191 is with respect to members of legislative assemblies. Okay, so these persons are MLCs also, so they can be disqualified on certain grounds. So what are these certain grounds means? For example, if you have seen, constitution itself has stipulated what will be the qualifications to contest for the parliament or the state legislative assembly. At the same time, it has also said parliament can bring by law additional qualifications. Subsequently, this Representation of People's Act 1951 was brought by parliament. Okay, then same happened in the case of disqualification also. Disqualification was also given by Constitution of India, and subsequently Representation of People's Act 1951 also is giving some set of guidelines on which particular grounds a person can be disqualified from his membership of the House. So in this way, Article 102 deals with these grounds for disqualification of members of parliament, and 191 deals with the grounds of disqualification of member of state legislature. So in this regard, we'll know what are these provisions. So if you see here, before that we need to know what are the grounds for disqualification prescribed by the Constitution of India. So a person, according to the Constitution, he will be disqualified. First one is if he is charged of office of profit. Okay, office of profit is one main provision under the Constitution of India. Office of profit. Yesterday we have seen a detailed video, why Telangana governor has resigned to contest as Lok Sabha member. No, so office of profit is one ground which can be a ground of disqualification. Second thing is if they have unsound mind. Unsound mind. Third is insolvent. If they're declared insolvent also, they can be disqualified. And fourth is if they lose citizenship of India. Okay, so if you have remembered, if Telangana people are watching this video, they might have known this, that one of the Telangana previous government's MLA, he was disqualified for the Indian citizenship because of some accusations that he has German citizenship and all. So at the time, his election was also disqualified. So subsequently, fifth one we have is any other law made by parliament also can set some grounds for disqualification. So these are the five set of things which were prescribed by the Constitution of India. So under this provision only, again, Representation of People's Act 1951 was enacted by parliament, giving the following grounds. So now, according to the Representation of People's Act 1951, these are the grounds on which if any person who was a member of the house can be disqualified if he has suited to these provisions. You can see, if he is not guilty of any election offences, okay, he should not be guilty of any election offences or corruption practices in elections. At that time, his membership will be there. But if he found of guilty, then he can be disqualified under Representation of People's Act. Means he should not resort to any corrupt election practices. Okay, that is why election code of conduct, model code of conduct will be clearly watched by the Election Commission of India. Then he must not have been convicted for any offense 2 or more years. This is what happened in the case of this Ponmudi and also Rahul Gandhi's case. Lily Thomas case is also related to this only. So next, he must not fail to lodge his election expenses within time. So within after election, within the given time by the Election Commission of India, he has to prescribe or he or she has to give how much he has spent, because there is statutory limits on spending of the election expenses by the candidates. No, within that only they have to spend. So if they found to be spending more and all, so then they can be disqualified on this ground. Then he must not have any interest in the government contracts or works. So if you have remembered, this happened in the case of Hemant Soren also, Jharkhand chief minister also. So on some allegations that he has some interest in mining licenses given to his neighbors or family. So on those grounds also he was accused. Then he must not be a director or managing agent or of and should not hold any office of profit in any corporation where the government is having at least a 25% share. And he must not have been dismissed from the government service on the grounds of corruption or disloyalty. He must not have convicted from promoting enmity between different groups, or he should not be convicted for offense of bribery also, or he should not be convicted or punished for promoting untouchability, dowry or sati. So you know, untouchability was abolished under Article 17 of Indian Constitution in any form, and dowry, you know, there is Dowry Prohibition Act of 1961, but still it is prevalent, you know. Again, you have sati abolition also. This happened in 1829 itself with the help of William Bentinck. He was the Governor General, and main person who played a pivotal role is Raja Ram Mohan Roy. So, but still, you know, in case if any person has resorted to these unsocial practices, okay, so at that point of time, they can be disqualified from their membership of the house. So now what happened? Tamil Nadu government, why they have approached Supreme Court is, as Supreme Court has recently stayed this execution or conviction of the particular member by the Madras High Court. Now Tamil Nadu government has asked the governor to reinstate back him into the cabinet. But subsequently, what happened? Tamil Nadu governor has refused this. So that means he's not adhering to the aid and advice of the Council of Ministers. On this ground only, they have approached the Supreme Court. So what are the arguments they have put forward? Means here they're saying governor has to act on the aid and advice of the chief minister only. No, so even in appointment of the Council of Ministers also, whatever the names that were forwarded by the chief minister, those only have to be finalized. There is no discretion for the governor. No, yesterday also we have seen. So there are some constitutional and situational discretions, but in choosing who have to be part of the cabinet and all those is a derogative, not it is a discretion of the chief minister itself. Okay, there is no such discretion there for the Tamil Nadu governor or any state governor. So then state also argued that recommendation is binding by citing this article 164 clause 1. So what is article 164 clause 1 saying? Whatever the aid and advice given by the Council of Ministers, that has to be followed by the governor. Has means it is binding on him. Then what happened subsequently? Recently a case was also quoted by the Tamil Nadu government. So Lok Prahari case that happened in 2023. So in this, what did Supreme Court say? Supreme Court say that if conviction was suspended, then disqualification will cease to operate. That means this is what even we have observed in Rahul Gandhi's case. No, when Supreme Court has stayed his conviction, immediately his Lok Sabha membership was reinstated. Okay, same way his membership also was now stayed. No, his conviction was also stayed. No, in the Tamil Nadu cabinet minister's case also. So now he has to be taken back into the cabinet. That is what state is arguing. Otherwise, if governor is not adhering to the judgment of the Supreme Court or the order of Supreme Court, then it is a clear violation of orders of the court. That means he has resorted to contempt of court. Contempt of court is under Article 129 of Indian Constitution, where if there is willful disobedience of court order, or if you're lowering the stature of the court, or these situations based on civil and criminal contempt, any person can be punished. Okay, so for not adhering the Supreme Court or any high court's orders. So under this, they have raised their objections. Then what is the role of Supreme Court in this regard? As Supreme Court has stayed his conviction under Section 8, Clause 3 of Representation of People's Act. Now, as his disqualification was stayed, he has to be reinstated. That is what the main thing observing from the Supreme Court judgment. Now, what is the stand of Tamil Nadu governor? Why did he say why he is not accepting the aid advice of the cabinet? Is he is saying that this person, if we are inducting the person who was accused of these charges of corruption, means this is a clear violation of constitutional morality. What message you are going to give by reinstating such persons into the cabinet? That is what he is raising his objections. At that point of time, now governor is also saying that conviction was only suspended or stayed for temporary period, but it was not completely set aside by the Supreme Court. No, that means Supreme Court did not say that this person has not resorted to any corruption related things, or he did not indulge in any disproportionate assets, and he was clean, like that. They didn't give any certificate. No, then how we have to take them back into the cabinet? That is what the role of the or the stand of Tamil Nadu governor in this particular issue. So as we have seen the main issues, here you have to quote about even Lily Thomas case, which is famous with respect to Section 8 Clause 3 of Representation of People's Act, okay, with respect to disqualification of members on certain grounds mentioned under Representation of People's Act. So in mains related answers, if these type of questions are expected, okay, so then you can quote one related judgment, which is a landmark judgment, right? Then we'll see the what is a practice question given in yesterday's video. You can see here which one of the following statements is not correct with respect to the office of governor. First one, governor can issue ordinances when the legislative assembly is not in session, or only when two houses are not in session. This is correct statement itself. Then governor at his own discretion can issue the ordinances whether the assembly in session or not. This is wrong. No, he cannot issue on his own discretion. The ordinance making power is also on the aid and advice of the Council of Ministers only. Then C will say governor must be satisfied that such circumstances must exist, then when which render it necessary to take him immediate action. Whenever it is necessary in some situational discretion, like if the chief minister dies, or if there is fall in government by not having majority, in those situations he can exercise his own, okay, discretion. Then governance ordinance shall have same force and effect of the act of legislature. Yes, within that particular approved time, within 6 months, it has to 6 months, 6 weeks is a maximum time. No? So within that, it has to be approved. So here option not correct is B. Then let's see the practice question given based on today's discussion. Here you can see first one. Under the constitution, a person shall be disqualified from being elected as a member of parliament if first one, he holds any office of profit under union government or state government. Second, if he is found guilty of any certain election offences or corrupt practices, if he is undischarged insolvent. Okay, based on what grounds a member can be disqualified under the constitutional provisions. Okay, so as we have discussed constitutional provisions with respect to disqualification, on two grounds I told you, no, one is disqualification regarding Representation of People's Act, another is related to defection. So in defection cases, you very well know that it is a presiding officer of the house who have the final authority, and in relation to this Representation of People's Act and all, who has to take the decision is at the central level President of India based on Election Commission of India's advice. In the state level, governor will take the advice, okay, based on the Election Commission's recommendations. So these are the authorities who have been given the powers to disqualify. Then what is the mains question given for practice? Discuss the significance and contemporary relevance of the Representation of People's Act 1951 in the Indian electoral system. Analyze its various amendments and their impact on the conduct of free and fair elections. This is what the mains question given for practice. Try to answer the question and try to put in the comment section. We'll know you and we can suggest you better. Then as we have reached the end of the video, today we have discussed why Tamil Nadu government has approached the Supreme Court and what is the Representation of People's Act and its provisions related to disqualification, on what grounds this Tamil Nadu minister was disqualified, and why Supreme Court has again stated, and what is the case that was referring. Okay, now Lok Prahari case we have seen it, and also we'll understand what will happen in the future. Okay, so these are the main things we have discussed as part of this video. Thank you for watching. Have a good day.